Fair Use Masterclass Series presented to you by the Copyright Working Group. Tom O'Brien is an assistant university librarian in instruction engagement, and he will be introducing himself shortly.
Again, welcome to today's presentation on fair use. My name is Tom O'Brien. I'm an assistant university librarian in the instruction and engagement department. Today's presentation is part of our ongoing effort to increase awareness of various points of interest related to copyright. So before we get into fair use, I think we should piggyback on Christy and Larry's presentation on copyright a couple of weeks ago and reiterate what it means to be a copyright holder. Being a copyright holder means that you, the copyright holder, have exclusive rights. Under Section 106 of U.S. copyright law, those who hold exclusive rights can reproduce copyrighted work. They can prepare derivative works. They can distribute copies for sale or other transfer of ownership or by rental, lease, or lending. They can, for literary, musical, dramatic, and choreographic works, pantomimes, motion pictures, and other audiovisual works, perform and publicly display the copyrighted work, and they can, for sound recordings, perform publicly by means of audio transmitters. These rights as to an individual work are divisible. They can be licensed to and exercised by different persons for different purposes. Nobody else can do this unless they are granted permission from the copyright holder. But what if you don't have a license to do this and you want to use someone else's copyrighted work anyway? Is this possible? And the quick answer is maybe. So what is fair use? Fair use is the copying of copyrighted material for a limited and transformative purpose, such as to comment on, criticize, or parody a copyrighted work. Being a copyright holder, in its simplest terms, perhaps the most important terms, fair use is a defense against claims of copyright infringement. Copyright infringement is any violation of these exclusive rights of a copyright owner of an original work. And just so we can see them once again, these are the exclusive rights. Any copyright infringement is the violation of any one of these exclusive rights of the copyright holder. So please take a look at this again, this screen, because these are what we're going to be trying to use to determine copyright infringement for the rest of the presentation. So fair use falls into two categories. The first category is commentary and criticism. This includes book reviews, music reviews, news reports, nonprofit educational use, courtroom use, scholarship, and research. And fair use allows you to reproduce some of the work to achieve your purpose. And I underlined some there because you'll see in some instances, some means one thing and in one case and means another thing in another case. Without the freedom to use portions of a copyright holder's work, there would be no way to criticize it. How can you criticize something if you don't have something to show that what you're criticizing? And the second category is parody. Parodies ridicule other works by imitating them. By nature, sometimes an extensive use of the original work is necessary to relate to the original material. If a copyright owner does not agree with your interpretation of fair use, the dispute may have to be decided by a court of law. And you're going to see in many instances, this doesn't just go to one court of law. If it is deemed not a fair use, you may be liable for damages. And by damages, we're talking about monetary damages. You should also know a few things. Just because your work is a comment, criticism, news report, instructional lesson, or research does not automatically make it fair use. Section 107 of U.S. copyright law provides 4 non-exclusive factors to be considered when you're talking about fair use. The first factor is the purpose and character of the use. Generally, and you see here, I have generally in bold, rather in uppercase print here. Generally speaking, nonprofit educational use leans towards fair use, whereas commercial use does not. You can still make it a case for fair use, even if you're using a work for profit. It's just, again, generally not favored. And you're going to see a lot of things like this, generally, maybe, and there's a lot of like unspecified things here, and that was done by design. Transformative use. When the use of a copyrighted works and altered or transform new work, this new work either has a new purpose or appears in a new context. Examples of this, and you can see here the picture, a parody of a song with Weird Al Yankovic, photos in a collage, quotes from an interview used as captions in another work, internet memes, and more.
Tom,
Yes,
can you just go back to that slide real quick?
sure.
Okay, so in other words, what you're saying here is that copyrighted works, whether it's an image, whether it's a book, or even a clip or music, even though copyright law gives certain rights to the creator for those works, fair use allows people to use it for some things, right?
Absolutely,
Mhm.
absolutely.
Yeah.
It's such an iffy thing, and the wording of copyright law is purposely worded that way because it's all open to interpretation based on case by case scenarios.
But it is something that we have rights to, especially in a library and educational and university setting that we're in.
Hmm.
Yeah. Okay. All right. Thanks.
Okay, so factor two is the nature of the copyrighted work. Is the work you're using fact or fiction? Uses of works that are factual or nonfiction are more likely to be deemed fair use. And that's another key thing there. You see, more likely. That doesn't mean it is going to be fair use, but it's more likely to be fair use. Use in a fiction is less likely, again, less likely, not will be. It's less likely to be deemed fair use. These creative works, such as music, art, fiction, and film, are original and are held to a much higher standard. Factor three, the amount and substantiality of the portion used. How much is too much? The less you take, the more likely you're copying, again, more likely your copying will be deemed fair use. There's no specific amount or percentage in US law to determine how much is acceptable, and no quantitative number of pages or words. The question really becomes, is at the heart of it? And you're going to see that word heart of things many times here. It's not just the quantity, but in many cases, what is copied is at the heart of what you're talking about. And a perfect example of that, and we're going to go over this in a second, but in 1985, a weekly liberal magazine called The Nation reviewed the memoir of President Gerald Ford. Now, only a small amount was used, but what was used was the heart of the book. And again, there's that word again, heart of the book. So that possibly negated the need for anybody to read the book. So at first, the court said, well, that's not fair use because nobody's going to need to read the book. The Court of Appeals reverses the decision in favor of fair use by the nation. So this goes to the Supreme Court. And now the Supreme Court rules in favor of the right of first publication, i.e. not fair use. So this thing goes back and forth, left and right, between different courts. So the fourth factor, the effect on the potential market or value of copyrighted work. You see I underlined potential there, and that's going to be a key factor in factor four. Perhaps the most important factor, does your use deprive the copyright owner of income? And a great example of this is when a sculptor made wooden sculptures based upon a copyrighted photograph. Now, the sculptor earned hundreds of thousands of dollars. The photographer sued and won. The artist, the sculptor, claimed that the photographer never would have considered making sculptures. And the court said it didn't matter because a potential market, and there's that word again, potential. Again, it's open to interpretation. Potential market for the sculptures of the photograph existed. So it's kind of like field of dreams things, like where if you build it, they will come. But guess what? The copyright owner will get the money. So going back to the Harper and Row Publishing versus The Nation, which had the excerpt on the Gerald Ford memoir. Based on factor one, the purpose and character of the use, and this is going to be kind of more of a, let's say we already know the outcome of this case, but what do you think, based on, if you could, in the chat, what do you think this leans towards? Is this leaning towards the fair use or not fair use based on factor one? And again, based on what you know, if you can type in the chat.
Yes, I also wanted to say, if you had questions or comments, feel free to toss those into the chat. Any questions you may have, just let us know. I'll be watching that, and I'll let Tom know so he can answer those.
Thanks, Chrissy.
Sure.
Anybody, any thoughts on whether or not this is fair use based on factor one? And again, that right there is what factor one looks at.
So,
The Nation Enterprises using excerpts from a memoir of Gerald Ford.
yeah, if I could add something, I'll just give you a little bit of detail about what The Nation had republished. Gerald R. Ford became the president after Nixon had resigned. I believe he was the Speaker of the House and the Vice President had resigned. And then it was just kind of like a few resignations that Gerald R. Ford became the president. So he wrote his memoirs, but what everybody was really curious about was why he had pardoned Nixon. So The Nation in their article had published it was like a big, like a paragraph, you know, it wasn't longer than half a page, but yet that was the question, you know, was it fair use for them to publish this information, or was it not, because people wanted to buy the book to see why the president pardoned Nixon, which at that time was a very controversial issue. So just to give you a little contents. Looks like Lori Rebar, I think she had in chat said that Harper and Row was a case that involved commercial use, and therefore use of his substance would not be likely to be seen as fair use. That is, it being the heart or substance of the book. So yes, and then Ken says that he guesses it would be, I guess, infringement because, or would it be fair use? I can't really tell, but he says, my guess would be yes, it is nonfiction and was being reviewed. So maybe it could qualify under fair use because it was a review, but it looks like the court looked at other issues in their ruling.
Absolutely, and you know that's my first thing was, well, it's a review, and but then it's a commercial use, and we're gonna get further into this with other cases, but commercial use would obviously for me lean towards not fair use, but you can see there's this stuff.
And then Tiffany Olin said that it would not be fair use because people would not buy the memoir because then they would get all the juicy bits. So, yeah.
Okay.
Yeah. Well
The
put,
juicy
yes.
yes, absolutely.
I'm going to use that next time we talk about fair use. Thank you.
So factor two, what do you think? Would this be fair use or not based on factor two, the nature of the copyrighted work? Is it fact or fiction? Fiction is less likely to be deemed fair use. Again, less likely.
Yeah, I like the part. I kind of like forgot about this second part that you said, that creative works, because they're original, are held to a higher standard. So yeah, that's part of copyright and protecting that kind of work and giving creators incentives to create and do it. And then Lori says that since this was a factual account, it would more likely be deemed as fair use. So that's kind of like a, well, wait a minute, but I'll just let it continue.
Yeah, which is interesting because this is where, you know, some of these factors are going to go one way and some will go the other way, and then you just weigh them and see which, you know, altogether, how does this weigh?
Yeah, Tom, you'll be talking a little bit about the weighing, the balancing factor, correct? Okay, good. All right, I thought so.
So Factor three, the amount used. Based on what you know about factor three, the amount used, how much is too much? And again, there's no specific amount or percentage. Does this seem like it would be fair use?
So like I had mentioned, it was roughly like a long paragraph that the Nation had published. And the book, I think, was probably about 300 pages.
Yeah, well, that's coming.
Oh, sorry. Okay.
That's all right. Again, this is just based on what we know looking at these factors. And obviously, we don't know the ins and outs of it, but I'm going to explain the Supreme Court's decision coming up. Factor three. See, one response came in.
Yeah, Lori had added that not a lot was used in quantity, but quality. So yeah, it's not just the quantity, as you said, but the quality of what was copied. And
Yeah. Yeah, and this gets back to the, I've already mentioned the outcome here, and I've already mentioned the heart of it. So this is probably factor three is kind of easy because we already know I've kind of said that if it's the heart of it, then it can't be fair use. So that was kind of an easy one, that factor three. But how about factor four? The effect on the market. Does your use deprive the copyright owner of income? Would this be fair use or not fair use based on this factor?
so what does
Anybody?
the crowd think? Yeah, are we
On four
depriving?
factor four only.
So Pamela says it might be a major factor in not considering fair use. So perhaps what the Nation did deprived Ford and his heirs any income possibly. Yeah, Ken agrees with that. Um, Lori, another Michiganian or Michigander like myself, says that she thinks that Gerald Ford's memoir would be interesting to read. Shout out to the Michigan people, but she wouldn't go out. But she said that she wouldn't go out and buy the book immediately since she knew the most important part from the reading in the Nation. So this is what she said.
Okay, so it's probably going to deprive the copyright owner of income. So overall, in your opinion, after weighing the four factors, and again, these are not, I want to mention here, and Christy had mentioned me saying this, the judges are going to take each one of these factors into account, and if they find three factors for fair use and only one against fair use, but if they deem that the one against fair use outweighs the other three for fair use, they may feel that it tips the balance slightly in favor of not fair use. So they weight these things, but just because only one is weighted for fair use or not fair use doesn't mean that the other three are weighted more. So that they have to really balance all four of these things and say, well, just because it's 3-1 in favor of fair use, maybe it's not fair use because of like number four, the effect on the market. So in your opinion, based on the four factors, was the Nation's use fair use?
Madeline added that people may be interested in buying the book because they didn't know for sure if that was the best part. So, so it could an argument possibly could be made for the other side too. But,
Absolutely.
yeah.
Absolutely. But let's take a look now at how the Supreme Court looked at this. Factor one, the purpose and character of the use. The Nation intended to benefit by depriving the copyright holders of the right to first publication. So we have not fair use one and fair use nothing. And again, that's just one factor. Factor two, the nature of the copyrighted work. Informal and factual and had public value, but the Nation exerted subjective descriptions of public figures from the author. There was nothing transformative about it. So not fair use, I don't know where the H came in there from. Not fair use two, fair use nothing. And again, this is the Supreme Court. Factor three, the amount used. There were only 300 to 400 words that were used from a 500-page book. But what was used, again, was the heart of the book. So now we have not fair use 3 to fair use nothing. And then what I had said earlier might be the biggest factor, because the effect on the market. The nation's infringement led to Time's cancellation of their contract with Harper and Row. And also, why would anybody need to buy the book? Unless, of course, somebody mentioned that maybe they just want to read something more, right? Maybe that's not the best part of the book. So this ended up being a not fair use for fair use nothing, based on the Supreme Court's use of the 4 factors.
But again, Tom, it's not necessarily a numerical count per
No,
se, but
absolutely.
the balance.
The balance, right? And this obviously 4 nothing, that's kind of an easy dig for the Supreme Court.
Mhm.
So yeah.
Oh, and then just something else that someone had added, sometimes the language, like the word intended in the first factor, seemed to be kind of a heavy word or consideration in their discussion. This
Yeah,
is
absolutely. All open to interpretation.
yeah.
So how serious is this? And as you can imagine, that green dollar sign plays a big part in this. The Academy Awards, watched by millions of people every year, right? What could possibly go wrong? Let's take a look. In 1989, the Academy Awards, Eileen Bowman's portrayal of Snow White lasted about 10 to 11 minutes. Disney sues for copyright infringement, unfair competition, and dilution of business reputation. They said that we have the greatest respect for the Academy and for all that it does. We were therefore greatly surprised and dismayed when we viewed last evening's Academy Awards ceremonies, only to see that our Snow White character had been used extensively without our permission. The president of the Academy Awards apologizes, and the lawsuit is dropped. And you can see out there I have an asterisk next to apologizes, and it was kind of a tongue-in-cheek apology, because the Academy also has a copyright on the Oscar name. So Disney spokesman says that we sue all the time. We look at these characters, here it is again, as the heart and soul of the company. Dozens of lawsuits are filed by Disney every year. In order to legally use Disney's characters, you have to get permission from Disney Enterprises, and they will either send you an approval in the form of an email or a letter, or they might simply say no. So here's an educational example of fair use using the 4 factors. For this one, I'm not going to let you know the end result beforehand. So let's see how you would interpret, there's that word again, interpret, the 4 factors in this case. The day that classes start, a professor asked that newspaper photographs of the Kent State shooting in 1969 be scanned from a microfilm copy of the newspaper and put up on the web for her U.S. history class. Only students in the class have access to the website, and the professor has not taught the class before. So based on factor 1, the purpose and character of the use, and here's factor 1, would you consider this fair use or not fair use?
All right, go ahead and put your thoughts in the chat box. If you want to give some briefly give your reasons, feel free to do that. So far, the thumbs up are for fair use.
Any reasons given?
Yeah, no, okay. Okay, Lori says that the context for using it would be considered educational, and Tiffany and Brian agree with that. Yep, so everyone's saying educational use, not commercial, and that it's for a class. Yeah, fair use for a class.
Okay, so it seems like most people are going fair use here. Let's go for factor 2, the nature of the copyrighted work. Factor of fiction, is this fair use or non-fair use?
Oh boy. Also, someone added that for the first factor that it was going to be on a restricted website, so.
Mm-hmm.
Mhm. Now, for this one, Sherry says the only hesitation is on the web. Does it mean password protected web space? And no, we were able to determine it would be only for the class. So
Correct.
password protected. Okay, and so far people are saying that these are factual works. Mhm.
Okay, so let's go to factor 3 then. The amount used. How much is too much? Is this fair use or not fair use?
Okay, so Sherry says that they're only using 3, so it would be fair use. Deepest agrees that it would be fair use, but quantity, that is.
Okay.
And then Madeline says that there are probably hundreds of pictures from that day.
Mm-hmm.
And then Lori says that, how people would interpret the images is very subjective. I mean, even though they're based on a factual event, interpretation is left up to the viewer.
There's that word again, interpretation.
And one person, Tiffany, said that how many pictures were used from the newspaper. Here was something that I'll throw in. One time I heard about a case about, well, did they use the photographs in their original size or dimensions, or did they use just a little thumbnail? So that could be a consideration too.
Mm-hmm.
What about the size, or was it changed a little bit?
Okay, so let's move on to the fourth factor.
All right.
The effect on the market. Perhaps the most important factor, does this deprive the copyright owner of income? And then, based on all of these, do you think this is fair use or not fair use?
All right. One person, Sherry, says it's unlikely to be fair use. Yeah, I guess if she or he, the professor, were to use it, and get the copyright permissions, it would cost them money, but that's not fair use necessarily. Yeah.
Mm-hmm.
But if these images or photographs appeared in the student paper, the student's really not buying the paper though, so it could constitute fair use. Another says that it's unlikely to deprive someone of a profit and that it would be fair use. Brian says that it would be fair use because the photos were culled from old microfilm copies of the newspapers. And one person says it was taken from a microfiche, so perhaps it can constitute fair use.
All right, so let's see how the Supreme Court decided this. Number one, the purpose of the use. The use in this case is spontaneous. It's the first day of class, and she has not taught this class in previous semesters. It is also for a purpose related to the course, a photo of an event in U.S. history being used in a history class, educational use. The purpose of the use favors a finding of fair use. Again, this is the Supreme Court. So we got fair use 1, not fair use nothing. I really need to figure out a way to say fair use without that. So
I use FAU.
yeah. So the nature of the work, factor 2. The photograph is of a news event and was previously published. Because this is a factual photograph, although there's some creativity involved, it's not a work of fiction or fantasy, so there is more room to claim fair use. And again, more room to claim fair use. The nature of the work slightly favors a finding of fair use. So it looks like it's going to be going towards fair use here, but the amount of the work used. The Supreme Court said the professor wishes to use the entire photograph. Because the photograph is copyrighted separately, in addition to the newspaper as a whole, the picture is the entire work. This weighs in against a finding of fair use. And so now the effective use on the marketplace. What did the Supreme Court say? The professor could attempt to get permission to use the photograph. Because there is no easy licensing mechanism to buy the picture itself, the effect on the marketplace for licensing individual photographs from a newspaper for classroom use is negligible. Because only students enrolled in the class have access, no other markets are affected. Guess what? On balance, this factor weighs in favor of finding fair use because 3 factors weigh in favor of finding it, and the 4th factor overwhelmingly favors it. The overall balance weighs in favor of finding fair use. So let's talk about some music. So can
And
I
a quick,
just,
oh,
yeah,
sorry.
no, I'm sorry, go ahead.
A quick question. Ken wanted to know if Van Halen got permission to copy it. Did you know anything about that? Or
I actually did look into that, and I did. That was a long time ago. I think the first time I gave this presentation, and they did get permission. That's an interesting point, and this is a couple of interesting points coming up as well. But I believe that Ken, I believe that was a permissible song.
yeah, they pretty much used the whole song, if I'm not mistaken. They just did it in their own style.
And it wasn't a parody too. It was I guess I don't know. This again, this is how crazy this stuff is. But can I just ask? Are we seeing my presentation to the PowerPoint now?
I am. Yes, we see the pretty woman, Julia Roberts.
There you go. Thank you. So let's talk about this here for a second. In 1989, Two Live Crew asked for permission to use the bass line from the famous Roy Orbison song, and they were denied. Interestingly enough, before all this happened, and even after this happened, Michael Jackson had 2 videos that were parodied. Dave Grohl from help me out here, Dave Grohl from his original band Nirvana. He even said, you know, when he found out that they were being parodied, he said, you know, you've made it when Weird Al is parodying you. Mark Knopfler from the Dire Straits enjoyed the whole parody thing. Don McLean of American Pie fame also enjoyed that and loved it. Joan Jett said yes to Weird Al as well. Instead of I Love Rock and Roll, he's had a song called I Love Rocky Road. There were, interestingly enough, some people that did not want at Weird Al Yankovic to parody any of his songs, and they included Jimmy Page, Paul McCartney, Prince, and U2. So getting back to Two Live Crew, again, they asked for permission to use this bass line, just the bass line, and they were denied. But
kind of like sampling, right? They wanted
exactly. And I have many friends that are into this, and I, as a guitarist myself, I have big problems with this myself, but what do I know? So Two Live Crew proceeds to record it anyway, and it sells 250,000 copies. Now, mind you, that's not $250,000. That's 250,000 copies, so that's a lot more than $250,000. So the music company sues for copyright infringement. The court says it was a parody and it made fair use of the song, which I agree, it's a parody. However, the appeals court says, yes, it was a parody, but there was a commercial nature to it and they collected a lot of money. So it's not fair use. So that brings it to, drum roll please, the Supreme Court. The case goes to the Supreme Court and the court favored a fair use decision for Two Live Crew based on the following, using the 4 factors. Number 1, the purpose. The work is transformative. It's a parody of the original and it leans towards fair use. Number 2, the nature. Parodies inherently copy popular works. That also leans towards fair use. This one I kind of have a problem with, but it is what it is. The amount used. Only 1 line was used, Oh Pretty Woman, and the rest was changed to a story about a hairy woman and her bald-headed friend who appeal to the singer. The heart of the song, there we go again. The heart of the song is the bass line, but it is what most readily conjures up the song for parody, leaning it towards fair use. And that was huge. And then the 4th The fourth factor also leans towards fair use because there was no effect on the market value for Roy Orbison's song. It was two completely different audiences. The next case is another musical case, and
Oh,
it's
can I
yes,
pause?
yeah,
Can
yeah,
I
yeah.
just, okay.
Please,
Also, can you go back to the last slide real quick?
sure.
Okay, thanks, Tom. Nikki wanted to add that Two Live Crew was a very controversial rap group. I mean, at that time in the 80s, it had a lot of explicit and adult lyrics that did face a lot of criticism. And she just wanted to point out that the record company had never been given them the permission because of the controversy, although it sounds like they did allow Van Halen to use their song and everything. So
I thought of this a lot while I was putting this presentation together.
mhm.
I certainly thought of that as well.
Yeah. But one thing I like to also say is that South Florida had a lot to add to copyright, fair use, and intellectual property, and here it is.
And then more is coming.
Yep.
So the next case is Jimmy Smith versus Drake. Jimmy Smith, excuse me, was a mid 20th century jazz musician, and Drake is a Canadian rapper. In 2013, Drake samples Jimmy Smith in his song Pound Cake Paris Morton Music 2. The Jimmy Smith rap says, "Jazz is the only real music that's going to last. All the other bullshit is here today and gone tomorrow." In Drake's version, he says, "Only real music's going to last. All that other bullshit is here today and gone tomorrow." Drake's label, Cash Money Records, licensed the track, but oh no, they did not license the composition. However, Jimmy Smith never even registered the copyright for his composition, and he died in 2005, 8 years before Drake's release. Jimmy Smith's estate, however, registered the copyright 31 years after the Jimmy Smith rap was released, and only after hearing Drake's song, and they sue for $300,000. I don't know where they got that number, but they sued for $300,000. And they said Jimmy never would have granted permission because he wasn't a fan of rap. So how did the court take this? Factor one, the use was transformative. That was the plea from the Drake side. And the court rejected the fact that Drake doesn't even reference Jimmy Smith's album. So they reject the transformative notion there. Drake said there was additional background noise and a shifting of the words, but that was rejected as transformative. Cutting "jazz is the" changed the meaning of the words. That was accepted as transformative, and the court said, Jimmy Smith's version is an unequivocal statement of the primacy of a jazz over all other forms of music. Drake's version has no qualifiers as to what real music is. And so these are two completely different ideas. Factor two, the nature of work, the judge rules against fair use. Factor three, the amount used, the judges, said that the amount was reasonable in proportion to the needs of the transformative use. Factor four, the impact on the market, and there was no evidence that there was any damage to Jimmy Smith's version and what he could make on his song versus any derivatives. So it ended up being a win rather for Drake in fair use. Here's a different example. Moving from music, we're going to go to movies, in a sense. The Betamax case. In 1970s, Sony develops the Betamax Videotape. And if you're old enough, you remember that guy on the top there. The Betamax Videotape recording that allowed for time shifting. And what that is if there's a program that's on at a certain time and you can't watch it, and we've all done this, you tape it and you watch it at your leisure. Walt Disney World, of course, and Universal take notice of this and sue Sony. After 2 years, the district court ruled for Sony on the basis of non-commercial home use being fair use, and that access to free public information is the First Amendment public interest served by this use. The Ninth Circuit Court of California reverses the decision and says it is not fair use. So guess where this goes? it goes to the Supreme Court, and the Supreme Court rules 5-4, just 5-4, in favor of Sony, based on the possibility that the new videotape technology had significant non-infringing uses, and that Universal Studios was unable to prove otherwise. It should be noted that television personality Mr. Rogers' testimony for Sony was taken into consideration. So I would imagine that having either Mr. Rogers or painter Bob Ross on your side couldn't hurt. How did this go down? Well, Disney and Universal tried to get Congress to protect them afterwards from home copying. But after 8 years of being on the market, the popularity of VCRs, they weren't called VCRs in the beginning, they're now called VCRs, it was far too widespread. Universal also asked for statutory royalty on the sale of blank videotapes, but that denied this based on the profits that they make from video rentals and sales. Ultimately, the fair use of VCRs increased consumer interest in films and watching them in theaters. So it seems like it's a win-win for everyone here. However, in 1989, Sony purchases Columbia Pictures. And by 1995, more than a half of Hollywood's US revenue came from home video, whereas 1/4 came from the theaters. So again, it all ended up, this whole crazy thing ended up being kind of a win-win for both sides.
Well, this is interesting, Tom. Can I just comment real quick about that?
Please.
This is an example of fair use being applied to an emerging technology. I mean, it was pretty cutting edge to be able to record things on TV from home. I mean, the younger people take that as a given now. But fair use is just so broad in a way in its language and its interpretation that it even has room to consider things like this. What happens when you get new technologies that allow you to do different things than the intended use? What are the rights of the copyright holders? What are the rights of the people who want to reuse this stuff, but without having to ask for copyright every time? So yeah, this is an interesting scenario because of all that.
Mm-hmm.
So thanks for including that. And I wanted to throw, and in tech, tech stuff is always interesting to talk about too.
Mm-hmm. Okay.
Somebody joked they were thrilled to be able to videotape MacGyver and then watch it later.
I'm right on that too. I'm right on that MacGyver thing. So moving on. The de minimis defense. Sometimes the amount of copyrighted material used is so small that the court allows it without even considering the 4 factors. In the movie Seven, 10 copyrighted photos appear in the movie without permission. The court said the photos appeared only briefly and were also obscured and out of focus, rendering them unidentifiable. De minimis is Latin for about minimal things. For those fans of the movie, the photographs used were in the background of John Doe's apartment about 1 hour and 17 minutes in. And so at about 1 hour and 17 minutes into the movie, the light box is turned on, allowing light to pass through the non-opaque portions of the transparencies posted on the box. Oh, what's in the box? And if you've seen the movie, you get that reference. During the next minute and a half, the light box and Sandoval's pictures, or portions of each, are briefly visible in 11 different camera shots. The longest uninterrupted view of the light box lasts 6 seconds, but the box is otherwise visible in whole or in part for a total of approximately 35.6 seconds. The photographs never appear in focus, and except for 2 of the shots are seen in the distant background, often obstructed from view by one of the actors. In these 2 shots, figures in the photographs are barely discernible, with one shot lasting for 4 seconds and the other for 2 seconds. Moreover, in one of the shots, after 1.5 seconds, there is completely obstructed by a prop in the movie. So because the Supreme Court ended up saying, because Sandoval's photographs, Sandoval is the copyright holder, they appear fleetingly and are obscured, severely out of focus, and virtually unidentifiable, we find the use of those photographs to be de minimis. And if for those that took Latin, I know it's probably de minimis, but There are two ways to say that. I've looked this up. So moving on, it is now time to stop, collaborate, and listen. Sometimes these things are handled out of court. In 1981, Queen and David Bowie collaborated on the hit Under Pressure. In 1990, Queen, David Bowie, and Vanilla Ice did not collaborate on Ice's Ice Ice Baby. Robert Van Winkle, aka Vanilla Ice, decided to add one note to the bass line, hoping to show a transformative use. Okay, so Ice was sued for copyright infringement and the case was settled out of court, with Bowie and Queen receiving an undisclosed sum and songwriter credit. Queen's drummer Roger Taylor once even said, "I don't like the song very much. He's a white rapper from Florida with a funny haircut." So some things to think about with regards to fair use. Subjective judgments abound. You've seen many cases, and there are many more, where it goes to one court, it goes to another court, and then it's even the Supreme Court, and you've got 9 justices, and you have 5 of them that think one way and 4 of them that think the other way. That's how close we are to a different decision. So maybe you have to get them on a good day. Non-commercial use is often fair use, but not always fair use. Benefit to the public may be fair use, but it may not be fair use. Merely acknowledging a copyright owner may be enough to determine fair use, but is not protection against infringement of copyright. To be sure, always seek permission. And interestingly enough, the US Copyright Office, is unable to provide specific legal advice for questions about fair use. That's the US Copyright Office.
So really, Tom, then it's up to the individual to look at these 4 factors and weigh them out individually.
Yeah, I want to say that, but I mean, half of these cases I've disagreed with so many things, and what do I know? You know, I mean, it is what it is, and that's why I say subjective judgments abound. And people are thinking about this a whole lot deeper than I am, and that gets through the whole reason why things are written this very non-specifically, so to speak, in law. So in case you are interested, also the US Copyright has a really cool page on fair use, and you can choose what you want. You want to look at Supreme Court decisions, you want to look at certain circuit court decisions, or if you want to go by category and choose like educational decisions or music, which I find fascinating, sculpture and all of this. That's all fascinating, to be honest with you. But there's a really cool stuff here. If anybody wants the PowerPoint to this presentation, instead of copying all this down, I'll be more than happy to send it to you.
Oh, I will be posting this to the Masterclass Series LibGuide too. So we'll send this and also the recording to everybody.
Okay.
Yeah.
Thursday's work session will be notable cases and their decisions. So that's going to be more like a workshop, and there'll be various cases, and all of us can kind of think together again based on the 4 factors what we think would have been the outcome of a case, and we have the Supreme Court's decision afterwards.
Yeah, we definitely encourage you attending this as a follow-up. One of the things that we've read a lot is that you will become more comfortable with fair use the more you try these scenarios, look at the different factors, and also the importance of the fair use cases and the fair use index that Tom had shown is that they really help us with interpreting the law and applying it to. Two Live Crew was a pretty significant case with fair use and parody, and that even though the case is 27 years old, it still helps us interpret how fair use could be put into play. So is there anything, I'm sorry, oh, and then just to go to chat, Brian had commented that it didn't seem like the bass line used in Ice Ice Baby wasn't any more of an infringement than Two Lives Crew use of the bass line from Oh Pretty Woman. Did you want to comment on that or say anything about that?
I agree. And again, what do I know? You know, that's why I'm not a Supreme Court justice, I assume. I totally agree with that. It's kind of crazy to look at these things. I've disagreed with so many of the cases that I've looked up on this, and you know, when you read the Supreme, again, maybe that's why I'm just me and not wearing that robe.
Well, I think also it also has to do with your tolerance for risk too. Like it looks like Luther Campbell and his group were ready to go, you know, take it as far as it could and contest it. You know, and that's who he is. You know, I like to read his interviews and what he has to
Hmm.
say about that. Whereas perhaps Vanilla Ice was much more risk aversive. Like maybe he didn't want to take that chance and maybe took a smaller payout as opposed to them taking him to the cleaners, because if I'm not mistaken, Vanilla Ice is quite prosperous, you know, and was even before he became famous. So, you know, I think maybe it had to do with the risk tolerance, perhaps. So,
Yeah,
how do you feel?
there's so many different ways you can look at this stuff. I mean, it's really that's what fascinates me about it.
Yeah. And then Lori asked, will us posting it be considered fair use? So would us posting the PowerPoints and the video be considered fair use?
You know what? That's a great question, and I'm gonna lean towards fair use for a couple of reasons. Educational. Yes, I am citing people, and I'm not taking all the credit for any of this stuff. It's not my thoughts, but it's a lot of this is factual stuff. So I'm leaning towards fair use, Lori.
Mhm. Yeah, and I thought a question could have easily come up too about the play in the videos on YouTube. A lot of people want to know, even if a pirated video, someone used a pirated video, would they be infringing on the copyright? And I guess the answer to that is no, you know, because just to view it, you know, that is just to view it if they're just watching it on their personal device or whatever. Um, because copyright law does say that downstream uses cannot be prosecuted. So even, but if you're using it for a class or something like that, you know that's gets much more tricky. But just viewing it on your
Right.
own
And
would
and
not
there's
be.
and there's no effect on the market of any of this stuff. If anything, I've just opened some eyes to stuff maybe somebody didn't see before.
Yeah.
You know.
Well, and I could also make the case that you only used like a clip of it as opposed to the whole thing. And you said very clearly it was Vanilla Ice and Queen and all the other performers. And you didn't say it was someone else, but yeah.
Thank you, defense attorney.
um, Also, there was another question. If we're going to be licensing this as Creative Commons stuff, then Lori, that's a question I did ask of my higher ups about if the library could consider if it wants to put Creative Commons licenses on some of its works. That's another discussion that goes beyond what we're talking about here. And then Deepa wanted to know if what about DJs playing music at an event? And gosh, anybody who does more with music, feel free to jump in. And DJs are getting paid to,
Handsomely,
basically play this music. So,
handsomely too. That they're very well paid.
yeah. I do know that if people want to play music publicly, um, that would require a copyright. That involves a copyright, so that it would need some sort of permissions. Like I do know that if a professional performer, wanted to play someone's song like a cover band, they would need to somehow purchase the rights to the music or to the composition. So
Which
that's one way I do know about that. But
which is really funny because I think back to all of my friends that are in bands that have gone out and played these cover songs, and I guarantee none of them, and I'm talking back in like the 80s too, you know, and in the late 80s and whatnot. I guarantee they didn't do that.
yeah, so that looks like it delves into the performing or the performance rights and for DJs to play music. I almost wonder if maybe they have to buy buy the rights. I'm not sure, you know, but that's an interesting topic to look into, and I'm sure this will be asked of us. So thanks for asking. You know, we'll have to do some homework pretty soon about that. Another question came from Hector. He wanted to know if you can take a song and put it into a video that you are creating. So what would you think about that, Tom, or anybody else who works a lot with music?
Again, I think we just said this. When in doubt, always seek permission.
Mhm. Yeah.
Don't just do it and think that it's fine.
Yeah, well, I mean, in Hector's case, he can probably do a fair use analysis, like as if he's only
Hmm.
going to use a clip of it or a little bit of it, or
Hmm.
heck, he could even distort it, distort the music a little weird, and you know, there's ways that he could change it perhaps and
Hmm.
say it's fair use. Um, and if he's not going to profit off it, perhaps, or he's not going to go and sell it to people, that's another consideration. Or he can find Creative Commons music, like music that has in the public domain. That way he doesn't have to worry about copyright. So that's another possibility. Use music that a creator said it's okay to reuse it, you know, just they might want some sort of acknowledgement, like, but maybe that's it. But yeah, Creative Commons is another possibility.
Sure, and that also gets to like what I was saying, where like certain bands like Weird Al Yankovic desperately wanted to parody Prince, and Prince, and he even said like one day he's just going to wake up and say it's okay, and he never did. And you know, and same thing with U2, you know, and a couple others. But then there's other bands that said, you know what, we're a part of that creative group, you know, and do with it what you can, and let's see what happens. And in a lot of cases, it brings attention to that band. You know, maybe not the way they wanted to, but it gives other people an appreciation for what they did in their original music. You know, so it really depends on who you're trying to cover.
Yeah, yeah. Hector added that for DJs, they pay for the songs by going to the Apple store, buying the CDs. But yeah, that's definitely something we'd have to explore further. Larry said that he knows that musical theater has to go and purchase the rights to perform it, even at the high school level. I guess they had to do that for Guys and Dolls and Little Shop of Horrors in his instance. Um, and then, yeah, so then really this isn't to scare you or to confuse you about fair use or using the information. It's really just to kind of give you some guideposts, some guidance, some considerations, where you can get the right information to make these kinds of decisions. Yeah. Oh,
Yeah.
and then Brian added, he had seen several junior versions of Disney musicals with elementary and music students. So yeah, they probably had to get performance rights for that too.
You know, and one thing I didn't mention too, I know I threw out there with like nonprofit, this, you know, educational use. You know, I've worked in some for-profit schools, and it's a completely different animal for them. You know, completely different animal for using anything in class, and it's
Yeah.
all about permissions.
So, all right. Was there anything else anyone had to add, or did you have anything else you needed? Anything else, Tom?
I just want to say thank you all for stopping by, collaborating, and listening to today's presentation on fair use.
Yeah, thank you. And as I mentioned, and Tom had mentioned, we're going to have a lab on Thursday, same time, same place. So everyone is invited to come join us for part or all of it if they'd like, and it will also be recorded. I'll send around the slides and the recording to this as soon as they become available to everyone. And I also wanted to let you know in April, we're going to have a couple more copyright working group events. I don't have the dates in front of me, but it's going to be like the 3rd and 4th week of March. Let's see, so we're gonna have a presentation on course reserves by Nikki Worrell and Jarrell Horn. And then the second one is going to be on interlibrary loan with Melanie Pola and different people from her department. So you're invited to attend those, and the links and the information to that will be forthcoming. So everyone, oh man, everyone's happy. You know, thank you to everybody. Applause to Tom. Thank you for keeping this interesting, informative, if not entertaining. One person, Tiffany, said only one complaint, not enough pretty woman. I say not enough cowbell. But that's it. So
I'll take it.
all right. Okay, well, we can, yeah, more cowbell. Well, we can stop recording, and thanks everyone for your time, and we'll see you soon.